All right, man. So let's talk about it. What happened in Dobbs versus Jackson's Women's Health Organization? That's what everyone's talking about. So, in short, Roe v. Wade was overturned. But let's get to some of the whys and the hows. Because I think it's important to talk about how we got here. So, in doing my research, the legal question that I found was, is a law banning nearly all abortions at 15 weeks constitutional? Because essentially there was a Mississippi law that was passed that banned abortion after 15 weeks. So the Supreme Court was put into a position to where we got to make a decision based on precedent, based on facts, and honestly based on ideology. It probably shouldn't be that way, but that's what it is. And obviously everybody goes to Roe v. Wade first because that is the landmark case that gave a constitutional right to abortion. But there's also a very important case that exists here as well, and Jesus Christ, and that case is Casey, and those are the two cases that kind of drive it: the Roe case and the Casey case. Excuse me, Parenthood versus Casey of 1992, and those kind of spell out the parameters in which abortion are constitutional. If you're not familiar with those cases, I challenge you to read up on them, get an understanding of them, because then that can paint a picture for you of what it is that we're dealing with and what we're going through. Now, I know a lot of us have strong opinions. I know a lot of us are hurt, but we really need to know what actually happened. So let's go to the background. For the first 185 years of this country, roughly, abortion was a state issue. There was nothing in the Constitution, in state constitutions, or even in common law that directly spoke to abortion. The states handled it as they saw fit, and that was the accepted practice. Then we have the landmark case in 1973, Roe versus Wade, where the court came and said and gave women the constitutional right to abortion under the given parameters, right? At that point, 30 states prohibited abortion, but after that, obviously, all 50 had to comply. So if you think about that, this is 1973. Think about your parents, think about your grandparents, and their ages, and how they are shaped by this, and how they can think about that, right? And I want you to remember that, because this was only 50 years ago. So there are those who are raised to believe that abortion is wrong, it's wrong, it's wrong, and it's not a thing, and those people are still living. And some of those people who are raised that way are decision makers. Then you have the 1992 case that I just talked about, Planned Parenthood of Southeast Pennsylvania versus Casey, and it brought into question the parameters in which abortion could occur. And there was a plurality opinion there, and the court pretty much upheld that the right to have an abortion established by the holding of Roe v. Wade, but it changed the standard in which we analyzed the restrictions of that right, and crafted the undue burden standard as a substitute. Undue burden standard, right? It's important to understand what these are. The undue burden standard is a constitutional test fashioned by the Supreme Court. This test, first developed in the late 19th century, is widely used in American constitutional law. In short, the undue burden standard states that a legislator cannot make a particular law that is too burdensome or restrictive of one's fundamental rights. So essentially, what Planned Parenthood versus Casey did was said, hey, man, it solidified that abortion is a fundamental right and that you cannot place undue burdens on people who want to receive an abortion. This all makes sense, right? Now, stay with me because I know we're doing a lot of background. But the background is important because the background is the information that we need in order to have an educated opinion on what's happened. All right. So then finally we get to the opinion. And unfortunately, everything has not been published. So you got to pull from excerpts, you got to pull from quotes, you got to pull from those who are in the know and their summary of what happened and the quotes that are there. Or you could have read the leaked opinion, which is pretty much on par with what came out. But there are, some changes because I think this opinion was leaked on purpose so that the court could get an understanding of how people would respond and then also address some of those concerns. I don't know if that's something we should make a common practice of, but given this situation, there are things that bother me more. Okay. So we have Justice Alito's opinion, right? That's the one we care about. That's the important one, right? And essentially, what I pull from his opinion, that was, um, you have Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. They were all on the same page, and that abortion is not deeply rooted in American law slash tradition, and because there's no pre-Roe precedent. So essentially, that means this is not a constitutional issue. So we're gonna pass this off to either Congress or the states. So by them rolling back Roe v. Wade, all they were doing was saying, hey, I know one court believed that this was our issue. This court believes that it's not our issue. So states, take it. In a vacuum, do I think this is the worst thing in the world? Absolutely not. Because it's the federal government saying, hey, we're going to allow the states to run themselves more and we're going to take a step back. Now, what has some people up in arms are, some more of the things that can happen here and what precedent this could be setting by sending our country back 50 years. Now, Brett Kavanaugh, he had his own opinion and he had a concurring opinion, but he was one important thing I think we should pull out of his concurring opinion is that he's against retroactively punishing Planned Parenthood, abortion clinics, doctors who've given abortions retroactively. He's against that. Like, can't punish those people because what they did was legal. It was constitutional in that state. And he's also against travel bans, which some states have talked about wanting to ban uh, their residents from leaving the state to go get an abortion. Now, Chief Justice Chief Justice Roberts, now he's come under fire for not being able to control the court, not being able to get, I guess, the conservatives kind of on the same page. And he was concurrent in judgment, but his opinion was a little bit different. He felt that the Mississippi law was constitutional by, restricting abortion to inside the first 15 weeks. But based on what I read and I understand, this is not something that he supported He did not support overturning Roe v. Wade and Casey as well. He just said, hey, in this particular case right here, we're going to put this in a vacuum. What the state of Mississippi is trying to do is constitutional. And I think if he was able to bring his conservative justices on the same side of him, I think he'd be okay. I think that the abortion groups, Planned Parenthood, the pro-choicers, and the pro-lifers would take it and go, hey, you know what? This kind of makes sense. It may not be what the pro-lifers wanted, but knocking it down to 15 weeks instead of some places 23 weeks. I think that was the accepted standard, if my research serves me correctly. But you go 15 weeks, okay, yeah, you knock off a few weeks, but he spoke to having a reasonable amount of time to make an informed decision. Makes sense. And then the dissenting opinions pretty much said, hey, this is not a vacuum decision. Overturning Roe v. Wade is not just overturning Roe v. Wade, which Justice Alito said it's just about abortion. It's not about overturning any other rights. It's just abortion, saying it's not a constitutional issue. And the liberal justices say, no, this is just a step. This is the first step in stripping Americans of some of their other rights and sending us back to where we once were. Some would say MAGA. We'll get to that a little bit later. So that's kind of the main gist of what happened here.